You've seen the headlines. The Supreme Court says a praying football coach should not have been fired. But there's so much more to this precedent-setting opinion that will impact future cases and millions of Americans. Hi, I'm Stuart Shepard, and this is First Liberty Live. We're doing things a little differently today because we wanted to go a little more in depth and give you a little more analysis of how the Kennedy decision and some other important cases at the Supreme Court will play out. If Kennedy had just been about Coach Kennedy and getting his job back, it could have been one page long. But instead, it was many pages long, and there's a lot more in there that we're going to unpack today. So I got a couple of people I want you to meet. Over here to our round table. We're set up kind of like we were sitting at a dining room table and just going to have a conversation about this here in our workspace here.
Do we have snacks?
I should have brought snacks. It would have been good. Bring on the Cheetos. I've got Kelly Shackelford, who's President, CEO, and Chief Counsel of First Liberty Institute, and Jeff Mateer, who's our Executive Vice President and Chief Legal Officer. Hi, Kelly. Hi, Jeff.
Hey.
There were 4 religious freedom cases this term, this session of the U.S. Supreme Court. And they impacted the law in ways that I don't know that people are understanding yet. Tell us what was moved, what advances were made for religious freedom, just looking at it from the 30,000-foot level.
Well, all 4 cases were considered moves in a pro-religious freedom way. I think the 2 cases that we had, that they usually wait and they hold the really big ones till the end. And the fact that both of our cases came down within 6 days of each other on religious freedom is somewhat of a hint that those are a little larger in their significance.
Yeah.
The first 2, one was about whether you could have a minister in the room when you were a convicted felon and were going to be put to death, whether you could have someone actually there touching you. The other one was about whether they could fly flags, at your city or government entity, and then exclude a flag if it was Christian or religious.
Right.
And those were good cases as far as some of the religious freedom elements that they advanced. But I think Carson and Kennedy were both very significant in ways beyond what the cases would even tell you.
Yeah. So, Jeff, what freedoms do we have now that we didn't just a few months ago?
Well, I think we have the same freedoms that we had, but I think now we've got some clearer explanations of those freedoms.
Yeah.
And I think what Kelly said is exactly right. I mean, both Carson and Kennedy were 6-3 decisions, where the Ramirez and Shurtleff cases, where one was 8-1, I think one was 9-0. So I think that in itself says something. And I have often said, I think we've always said, I'd rather win a case 5-4 than 9-0. And so we get to win 6-3 because what I think you've seen in those cases, and the good news for religious liberty, is the conservative justices, the 6 justices appointed by Republican presidents, are united in defending religious liberty. Now, not all at the same strength, but at least united in the principle of defending and restoring religious liberty.
And the idea behind what you're saying is, if it's 9-0 or 8-1, it's not going to go as far as it might if it were 5-4, where they're divided on it, right?
Yeah, I mean, Kelly and I we talked about the Carson case, which was the main school choice, and I said, look, I think after the arguments, I said, there's a world where that case is 9-0 and we win.
Yeah.
And what was your response?
I said, I think it's going to be 6-3.
Yeah.
And that's why he's the president.
And which is good, like Jeff says. I mean, if it's 6-3, then they're actually, they're not sort of speaking in DC speak, or they're sort of watering things down. They're actually going to, what is the original meaning of the text? What does it say? Let's give it its full protection and power. And that's what happened both in Kennedy and in Carson. In both those cases, if you say what the case is about, and people would say, oh, I mean, I've been all over the country. I was just at a military base where numerous people came up to me and said, hey, I really appreciate this case. All they know about the case really is Coach Kennedy should have been allowed to pray.
Right.
But wow, when you read what's in the decision, so much bigger. And so same with Carson. I mean, school choice case. Yeah, that was a good victory for school choice. Some states like Arizona, et cetera, now have a statewide program. It means that you can't exclude religious or Christian schools from that program. Again, so much broader than that if you actually understand and read what they really said. So that's the thing is these were, I would call Kennedy like one of those once in 50 years cases that changes everything directionally.
Yeah.
There's a lot that has to be built out now and understood where those parameters are, but it's like a huge battleship that's been going in one direction for 50 years. It literally just turned around. And so that's one of those, once in a lifetime, I think, major landmark rulings that's going to start something new.
Now, I want to set the table for understanding it, and you're leading right into it. And that is, I've been talking about these kinds of cases for a long time. You guys have been fighting these kinds of cases for a long time. And there's a position that schools historically have regularly taken, and they often default to rejecting any appearance of, and I'm putting in air quotes, endorsement or establishment of religion, no matter how slight, no matter how nuanced, no matter how tenuous it might be, if it's possible at all that someone somewhere might take offense, then their default reaction was, we got to shut it down. You can't let it happen. So there's no Christmas songs in the school program. We can't have Christmas break. We got to call it winter break. You can't have your graduation speech mentioning Jesus. All those things, we got to stop them because. How did we get there? Let's talk about the history of this. What led to that knee-jerk reaction by so many school officials across the country?
I mean, a lot of bad decisions, really starting back before, but really the one that everybody notices is the Lemon case. They put all these things into the law that weren't in the Constitution. Again, the Constitution says the Congress shall make no law respecting an establishment of religion. We didn't want there to be a national church established that we all had to support. But in Lemon, they said, no, it goes further. And they threw out principles like separation of church and state, which again, it doesn't say that in the Establishment Clause, okay? It developed a test where if your purpose was religious, it struck down the law. Now, think about that. You could have, let's say you had 3 people on your city council pass a law against murder, and they did it because they thought the Bible position on that was a good one. You strike down the law because of their purpose, because they had religious motivations and it's ridiculous. That's nowhere in the Constitution.
Yeah.
Because its primary effect was to advance religion. None of this is, and it led to this wall kind of feeling of, oh wow, anytime religion is near government, religion has to retreat. Well, government's everywhere, and so this led to this hostility to religion, and this, as you say, this sort of brooding hostility, really, because it's like, okay, is there an appearance here? Could somebody think,
And that somebody is always an activist, by the way, who will sometimes drive out of their way to be offended so that they can bring a lawsuit, right?
And all of this, the endorsement test, which you're mentioning, sprang out of the Lemon case. All of this goes back to those bad interpretations that I'll remember back in law school, 35, 36 years ago, reading these cases going, I mean, anybody with a brain that was reading those and was being fair-minded went, what? This is not what it says. And, it's similar in ways to people that were reading about Roe v. Wade.
Yeah.
They would read the Constitution and they'd go, there's no right to an abortion in here. This is not a federal constitutional issue. This is a moral issue that people can make their own decisions on in their own states. It's the same with Lemon. They created this fiction, and it led to a lot of problems, all kinds of confusion. And when you're confused, you just shut it down. And that's what was happening in all of our cases. I mean, we have lots of examples. One of the funniest ones to me that I thought was so typical is at Christmas. They would have a program at the school where all the kids would sing about Christmas, and all from every perspective around the world, in America, and they would do every religious background, every culture, but then they would say, but we can't do the Christian one because that's against the law. This is the kind of weird stuff that was going on for many years, where they were just sort of a religious cleansing was going on in our public schools, and in our government displays, and that was never what the founders wrote in the Constitution.
And things really just changed. I want to read something, and Jeff, I want to get your take on this. It's from the opening of the Kennedy opinion, and it went on for dozens of pages. Justice Gorsuch is describing in this section why the school district disciplined Coach Kennedy. And this is a quote. The school district did it, he says, quote, because it thought anything less could lead a reasonable observer to conclude, Gorsuch writes mistakenly, that it endorsed Mr. Kennedy's religious beliefs. That reasoning was misguided. Both the free exercise and the free speech clauses of the First Amendment protect expressions like Mr. Kennedy's. And then at the conclusion of the opinion, he repeats the chorus, if you will. He writes, quote, here a government entity sought to punish an individual for engaging in a brief, quiet, personal religious observance doubly protected by the free exercise and free speech clauses of the First Amendment. What's the significance of being doubly protected? What's he getting at there?
Yeah, no, it's very, very important because as Kelly talked about, you had what had developed after the Lemon was that the Establishment Clause, the Lemon case, the Establishment Clause always trumped free exercise and free speech. And that if your personal free exercise, your personal free speech always had to give way to a claim of endorsement under the Establishment Clause. And so what Justice Gorsuch is getting at is that mistaken belief that Establishment Clause always trumps free exercise and free speech, or that those clauses, the three clauses, are in conflict.
Yeah.
What's wonderful about this opinion is no, they're not in conflict. And of course, the framers didn't draft a First Amendment that internally conflicts itself. You can't do this, but this trumps it doesn't say that at all. The language is plain. And so what Justice Gorsuch is saying is this double protection, when you have someone who's exercising their religious beliefs, and in doing so speaking, they have both free exercise protection and they have free speech protection. That's double protection. And that's exactly what our brief, we made that argument, doubly protected.
Yeah.
And Justice Gorsuch picks up on that theme. So it's extremely important.
Think about this. For 50 years, we've had this fake violation of the Establishment Clause. The endorsement test is nowhere in the Establishment Clause.
Right.
We've allowed this fake thing to shut down two fundamental constitutional rights that are in the very first words of the First Amendment. It's been crazy, but yet if you'd ask any of us 5 years ago, can you get that kind of overturned in the next 3 or 4 years? We would have laughed at you.
Yeah.
Well, there was probably, I don't know, we have to go look. We need to get a count, but I'm going to guess there were 20 or 30,000 citations to Lemon.
Oh.
Over the past 30 years.
Yeah, and that you may be underestimating.
Yes.
I mean, because Lemon, what you'd have to do today, prior to the Kennedy case, is if you were in a religious liberty case in which it was against the government, and the government was asserting, we stopped you from speaking, we stopped you from exercising your religious beliefs, then you essentially had to make like 3 different arguments around the Establishment Clause. You had to say, well, our conduct complies with Lemon, it's not coercive, it's history and tradition supports it. You basically had to make 3 arguments because you didn't know what test applied. Because despite for over a decade, the Supreme Court questioning the Lemon test, they had never said Lemon is dead.
Right, yeah.
Well,
they kept hinting they'd like to get rid of it, but they kept it on the shelf to bring it out whenever they needed it.
As someone practicing in this area, you had to make all the arguments. Because even though we believed not only was Lemon dead, it should have never been alive, you still have to convince judges to win cases on behalf of clients.
And Kelly, you and I have talked about, on this program, we've talked about the fact that so many religious freedom cases were brought up as free speech cases because it was so hard to win as a free exercise claim. You just couldn't do it, so everybody argued it as a free speech kind of argument.
Now that's a different problem.
Yes.
That's a different problem, which is...
the Smith decision.
That's next. That's next. That's next. We're going after next.
But with this doubly protected, does that at least move that a little bit? Does it make any shift at all?
Well, essentially what happened in this case is they clearly targeted Coach Kennedy because his speech was religious.
Right.
Okay, in those cases, those are clear free exercise issues. What the Smith case says is when you have a government action that shuts down people's religious freedom, but it's not targeted only at religion, it's broader than that, then there's no violation of your free exercise right. So, they could do all kinds of stuff like no alcohol to minors, and the next thing you know, they're arresting the Catholic, priest for serving, alcohol in communion. And when he says free exercise of religion, they say, no, you haven't read the Smith decision, which says this doesn't violate your free exercise. So that is something that the court mentioned in this case. It caught everybody's attention. The first time we went up with Kennedy, they said that, they noticed that there was a free speech claim was the first thing to reach them and not free exercise. And then they mentioned the Smith decision and some other decisions that they clearly think are problematic.
They suggested they'd like to revisit it, perhaps.
But we didn't end up having to go there to win.
Okay.
But the thing really the lemon part, and Jeff, he can chime in too, but this is shocking. I mean, when we did the Bladensburg Cross case, we looked up at the court and we said, there's a new composition of the court. You have Kavanaugh on the court. You have Gorsuch, he's very pro-religious freedom. And we thought, we might be able to get rid of Lemon. And that was our goal. And so we knew it was great facts. This is a Veterans Memorial. And so we went after sort of we went after the grand slam instead of the bunt single to win the game.
Yeah.
And we got a grand slam somewhat in that 5 justices said, we're not following Lemon. But we knew it was cabined into the context of like a public display.
Right. And that's the difference between that and Coach Kennedy saying a private prayer but in a public place, right?
And I sat down with, Jeff probably remembers, I remember this meeting. We sat down with all the legal staff and said, we've got to get this into the schools because this is where it's causing the most damage. But my theory was it would take 10 to 15 years to do that. We would have to move step by step, inch by inch, because this is young children. There's all these cases cited, and so we didn't, in our briefs, we didn't say to the Supreme Court and Kennedy, by the way, don't only rule for Kennedy, don't only be the first case to ever come down in favor of teachers and coaches and their free exercise rights, but we'd like you to throw Lemon out and all the public schools. We didn't ask for that. This was a total surprise in an incredibly good way.
Yeah. So Bladensburg took a big hunk out of it. The Kennedy case, it's practically gone.
No, it's dead.
Let's take a vote. I'm hearing
it's
dead over here.
It is.
Okay.
And what I would point to anybody, and I know there's some people out there, and certainly on the left, and perhaps even people maybe who are a little jealous.
This is helpful to unpack this stuff.
Of the result, but Sotomayor says so. So in her dissent twice, says that this case overrules Lemon. Lemon is overruled. Lemon is dead.
So what's the new test? What happens now?
Well, that's
good question.
That's what I'm saying.
That's the question.
Now, they would say, the court would say, it's some sort of history and tradition test of, is this a type of religious practice or activity that goes back to the founding?
Is that in a specific case, or I keep hearing it referenced, but I don't know where it comes from.
It was really brought out in a dramatic way for the first time, I think, in our Bladensburg Cross case. It was also in
Town of Greece.
The Town of Greece case.
Which was prayer really before a public meeting.
And which really goes back to Marsh v. Chambers, a long time ago, about whether you could have a chaplain open in prayer. And they were like, well, it's kind of hard to strike this down when the founders who passed this amendment had a chaplain open their session in prayer. So maybe if it's a part of the history tradition and it's always done that. But I don't know that addresses every situation. And so that's what I'm saying about how we just had a huge, beyond our beliefs, victory. And we turned the ship. And so, but we still have to build out where we're going next. What are the parameters of the negative, the hostility to religion is over. That whole approach of hostility to religion by the government, over. But what does it really look like? What does the establishment clause really mean in these contexts? We've been blinded for that for 50 years because of these bad cases. Now we can actually look, and we're going to have justices who they're going to try to find what is the original meaning of the text. What was this supposed to do? And we're going to have to help them do that in future cases. And so it's great news, but we still have some serious work to do for the future.
Gorsuch hints at some of that. I mean, you see it in the opinion, and he has 6 judges join, although Kavanaugh doesn't join for part of this analysis that I'm
Which
about to
was
talk
strange, but
Well,
there's one little section he said, I'm not on in on
and
that
it's
one.
about coercion, and it's whether
Coercion,
yeah. Whether if that's the test, whether and what's great about Gorsuch's opinion is it's got to be real. Like, you really have to be forced to. It can't be a shadow. It can't be the mere threat.
Which in the Kennedy case was the claim that because he's a coach, the students may have felt coerced. We're back to nuanced.
Somebody sees him from 200 yards away and goes, "Oh, I feel," that's gone.
And that's clearly, Sotomayor brings that up. That's clearly what 3 justices thought, 6 rejected, that's not it. And then in Gorsuch's opinion, he points out if that's true, then that means a Muslim teacher wearing or hijab, or a crucifix, maybe a Catholic teacher wearing a crucifix, or a Jewish wearing a yarmulke. All that would be the same. If you're just displaying it, which obviously the court says obviously we're going to protect those things. So I think in that, Kelly has said it, but Stuart, I want you and our viewers to understand, the Kennedy case is huge. This is real. This is a case that they're going to have to redo the textbooks in law school. It is, when we would read, you would read today, before Kennedy, you'd read Smith, you read Lemon, right?
Yeah.
Today, going forward, you're going to read Kennedy.
Yeah.
Because both on free exercise and establishment clause, it's a game changer. And Kelly's right. It's not, he's not overstating. Kennedy is the case of the past 50 years.
And that's why I wanted to have this conversation to help all of us understand what you just said. This thing is way bigger than I think even the people who wrote the news articles about it caught on to.
There's a service. You say we could get in the weeds, so I'm going to get really in the weeds.
I'll let you. Yeah.
There's a service that checks the citations of all the cases. It's called Shepherds.
Okay.
And
fine name.
And what we do is, because if you look at a case, you want to make sure it's not like it hasn't been changed or overruled or whatever. And there's a little notation, a flag, that appears if it's been overturned.
Yeah.
Lemon now has that flag.
Okay.
So however many, we need to go look this up. Maybe it's 50,000, 30,000, however many citations in the last 50 years.
Out of here.
All those. Now, I want people to think of what that could mean. All those cases where somebody was told prayer wasn't allowed, where some monument was torn down because it was religious or not allowed. You can go into every community across the country. They can all now revive. All those cases could come back up. They have a right to, all those city councils could do what they plan to do. This is really a return to the American founding of what we are. And so when you see that potential, this is going to be a project of ours to do that very thing, to go back and restore. It's no good if we've won a right, but nobody in every community knows that they can go back to exercising their freedom. So it's a societal change in a dramatic way.
And you're really hitting it. This is why I wanted to have this conversation, because the first thing you report when you win a case like this is, yay for Coach Kennedy.
Right.
Good on him that he gets to go back and be restored to his position at the school. That's what the Supreme Court says has to happen. But as we got looking at this, there's so much more that this impacts, more than I think any of our people. Even I didn't get it all. I wasn't understanding. This thing is monstrous in the impact it will have as far as how religious freedom cases are dealt with in this country.
I know, and you've got that. So you've got death to Lemon. I'll call it death to Lemon.
Yeah.
And then think about, the area that Kelly's been working on for 30 plus years, the rights of employees in schools. And when we were thinking, has there ever been a Supreme Court case?
Never.
Ever been a Supreme Court case?
Not till last week.
Until Kennedy?
Nothing on the
this?
religious freedom of a coach, of a teacher, nothing.
And then expanded out of schools to government employees.
Yes.
Yeah.
Because now we've got, it's not just a school employee, this was a government employee. And so this is a fundamental victory for the rights of government employees for their religious liberty
There's
rights.
a lot to be worked out on that. I mean, even since the opinion, there's been things coming out that about how much of the rights of a government employee can be stripped away with regard to their free speech or their expression of their opinions or their faith. And so this is all going to now you're going to have Kennedy come into play. And so it's going to affect, like you said, Lemon and the whole area of people who work for the government and how many of their rights they lose because they work from the government.
Literally millions of people. That's not an exaggeration. It's a literal statement.
Because this was their argument. Their argument, by the way, if people don't realize this, was Kennedy was a government official. He was a government official, and therefore, if he says anything, it's the government saying it, and therefore he can say nothing religious.
Even to himself. I mean, that was the
That was it.
overreach. of this.
Anywhere.
It was
Yeah.
demonstrably religious is what was
Yeah.
in their letter. Anything that anyone can tell, a spectator, not a student, just anyone, could see that he was doing anything religious, violation, and they can fire him for it. So a total stripping of his First Amendment rights. This is what they were arguing for in the case.
Many of us have long seen a different understanding of the Constitution than what we've been dealing with for so many decades. And Justice Gorsuch put those thoughts into writing in his opinion. I want to quote this section, and it starts with nor, but it'll make sense when you get through it. Nor does a proper understanding of the amendment's Establishment Clause require the government to single out private religious speech for special disfavor, which plays right into what you were just saying. The Constitution and the best of our traditions counsel mutual respect and tolerance, not censorship and suppression for religious and non-religious views alike.
Amen.
What's he getting at there? Help us understand what he hit.
He's getting at for years, it was sort of a religious cleansing in the schools, that you could say anything, but if somebody said something religious, everybody would freeze. They would try to shut it down. And this is students, student clubs, coaches, individuals. I mean, it was always, and what it created was sort of a religious KGB. That was what our government was, to find religion and stop it, instead of, respecting people's individual rights and realizing that they have a right to express their belief, that religion is not the new pornography that has to be pushed out of public society, but this is what had happened. And tolerance, respect for the people who disagree. And, I love that Coach Kennedy, that was always his message. He was always, look, I'm standing for everybody, even people who don't believe in God at all. This is their First Amendment rights too. And that's what this opinion means, and that's what Gorsuch is talking about there.
And the best part about Coach Kennedy is he wasn't an activist trying to set up the situation for a lawsuit to happen. He was just a Marine serving as an assistant coach for a high school, and he felt compelled to say a prayer. It was all real. It wasn't contrived. It wasn't set up to try to bring a case. It was the real thing. And I think all the reporters who got to meet him had that same impression.
Look, when this case came in 7+ years ago, and we first got it, none of us sat there and thought this case would be a Supreme Court case, and this would be the case that would fundamentally change Establishment Clause law and free exercise, free speech rights for government employees. What we wanted was, and we thought, the school district would simply just let him do his thing. And you know how it works sometimes when government tries to interfere. What could have been fixed very simply, just let him go at the end of the kneel for 30 seconds and be done with it.
How hard is
and
that?
The case is over. It's done. But instead, 7 years now later, we've got one of the most fundamental, transforming Supreme Court victories. So in some respects, I guess we should thank Bremerton School District and its lawyers for fighting and for not doing the right thing that could have easily fixed this. But you're right, Stuart. I mean, Coach Joe just wanted to pray. That's all he still wants to do.
Didn't ask for any money.
No.
Just wanted his job back and to be able to pray at the end of the game. When the kids were facing the stands singing their fight song. So that's where it was at the end. And they said no. They said no. Anybody can see you at any time. Anything quote demonstrably religious, not allowed. you'll be let go, and that's what happened.
I want to cite one more section of this. We don't have to explain this one, but I want people to hear it because it gives a sense of where Gorsuch was thinking as he wrote it all. He said the district's case, the school district, quote, hinges on the need to generate conflict between an individual's rights under the Free Exercise Clause and Free Speech Clauses and its own Establishment Clause duties. And then he writes, in truth, there is no conflict between the constitutional commands before us. And Jeff, you hit on that earlier. There's only the mere shadow of a conflict, a false choice premised on a misconstruction of the Establishment Clause. And in no world may a government entity's concerns about phantom constitutional violations justify actual violations of an individual's First Amendment rights. You can't write that sentence more solidly than that. That lands like a sledgehammer.
And look, Jeff can speak to this too, but my entire career, that's what we've been dealing with. You go, let's say it's a school district, taking away some students' rights or some club's rights or whatever. Their argument is, well, we're trying not to violate the Establishment Clause. And it's like, well, there is no violation. Well, but we're justified even if our concern is to try to not violate these. So a shadow or a phantom violation is allowed to strip away other people's clear constitutional rights. I mean, it's never should have been that way. And we always have argued against that.
Yeah.
Now it's as clear as day that you can't do that.
First Liberty does the cases that we do. I mean, we try to be selective about the ones we pick because we stay exclusively focused on religious freedom. That's all we do. But they also, as you look at each one, they fit into a larger strategy that's trying to change how religious freedom is regarded by the courts. And I know, Jeff, this has been a particular focus of yours as we select cases. It's to move that larger weight, that larger wall, to push it farther back so that we have space to enjoy our freedom, to have the free exercise of religion. Tell us about that strategy and how the Carson case and Kennedy case, for example, played into that strategy. How does this all come together in those?
Yeah, I mean, you think with the end in mind. The end in mind is to have the courts interpret the First Amendment in accordance with what the original meaning of the words were, what our founders intended.
Yeah.
Which our founders intended broad free exercise, and they did prohibit establishment. We don't want an established church. We don't want to be told that we have to pray a certain way or pay taxes to support a certain church. So what we do in looking at cases is we knew Lemon was an area that was restricting. And so when I came and joined now 10 years ago, over 10 years ago originally, before my leave of absence, for a little bit of time. I mean, the plan was we want to go after Lemon. We want to take down Lemon. We want to restore the founders' vision of a proper understanding of the Establishment Clause. With that, as Kelly said, in the school context, we wanted to correct a series of horrible decisions that come from Lemon that involve with things like, students praying, but not, they're praying, but not the government, but the government because they're allowing them to pray. Therefore, it's an endorsement and establishment of religion.
Yeah.
That might be a new goal. There's a horrible case called Santa Fe that came out of Texas that Kelly worked on when he was a young lawyer. That's how old the case is.
Yep.
Which talks about student speech and when students being able to exercise and whether that's attributable to a school or not. But we wanted to go after those cases as well. And then finally, the other area and the area that we've had, so Lemon is about 50 years old. An area that's 30 years old is free exercise, and there's this horrible case, Smith versus Employment Division. And in Smith, it essentially says that if you have a generally applicable law, so it generally applies to everyone, then you can burden religion. You don't have to have a compelling interest to do so. It doesn't have to be narrowly tailored. If it's generally applicable and treats religion equally, then it's okay. Kelly did a great example of that would be if a city or state said, in no circumstance can minors consume alcohol. That, doesn't sound like that bad of a law until you start realizing that some serve communion wine that has alcohol in it. Well, if they said you can't do that, if the law is generally applicable under Smith, it's okay. So we don't think that, and actually it's not what the founders envisioned. And so that's one of the areas that we're looking at cases. And quite frankly, when we first got Kennedy in, we thought that Kennedy could be an opportunity to challenge Smith. But as it turned out, because of the school district's actions in targeting Kennedy, it took it outside Smith.
Yeah.
And so those are the areas. So what we try to do is look at those areas in Establishment Clause and in free exercise where we're really trying to bring back the original understanding that the framers had.
So there's the win, but there's the larger win, and that's really what the strategy is about, is to get that larger win, right?
Absolutely. And look, I want to be real clear. We have a strategy. We have to be moving. We have to be aggressive. We have to be going ahead with the best cases. But as this case shows, as the Kennedy case shows, God's in charge of things, and he's got a better strategy than we do. But I think he'd like us to be moving instead of sitting on our rear end.
Yeah.
So we are moving forward with what we think is the best way. And if he wants to throw us a surprise like he did in this case, where we jump ahead about 10 steps, I can tell you when during the oral argument, when Justices Kavanaugh and Gorsuch brought up getting rid of Lemon, every one of us, our eyes were about that large. And it was, so I didn't want our supporters, number one, it's because of their support in allowing us to be where we were. But God had a plan. So we're going to try to be diligent. We're going to try to figure out how to move these things. And we've got some huge opportunities now, right? I mean, we've got this issue of there's no lemon, what is it?
Right.
Right, that we have to build out. And then there's also this Smith decision, which has basically got a noose around the free exercise clause. And so we still have some work to do, but we feel real confident about our court. And if we can just bring the right cases and do that, I mean, God is really blessing what we're doing right now.
We have at least 3 cases right now that have at least the opportunity to make it up to the Supreme Court. So there is work to do. Jeff, any final words from you before I let you go?
I mean, there's a lot of work to do, and I'm, we're thankful that we said at the beginning of this, we had 6 justices join us in these opinions, and these are strong opinions.
Yeah.
These were not narrow victories, and that we have 6 justices joining them. I mean, the future, there's no doubt we've got lots of battles. I mean, the cases, we're getting new cases every day. But I think the future is really bright because if assuming we can keep it to 6 justices, of course.
Kelly, final word.
Yeah, I'll say this. This is sad but true. A lot of times our side, as soon as they get a win and an opportunity, they think it's time to sit on the couch and eat potato chips, right? And that's an incredibly foolish thing to do. The image I would give people is we've had a locked door. God just blew open the door, and he wants us to walk through it. So if people who are investing don't feel positive about investing now, I don't know when they would, right? I mean, we've got more opportunity than we've ever had. We've just proven what's happening and the direction the Lord is moving. So now is a time to take advantage, because that window could close. I mean, God didn't say, I'm about to open a window of opportunity for you for the next 20 years, 30 years. We don't know what could happen. I mean, this could all change fairly quickly.
Yeah.
And we could be at a situation where, I mean, all it would take is one health situation, and we could have been in a situation where Roberts is the deciding justice, which changes everything.
Yeah.
Or if a couple where now it's totally different makeup of the court. So while we have opportunity, we need to move, and we need to bring great cases and have an opportunity to really open up religious freedoms in ways we haven't seen in our lifetime, and we're at the start of that. That's the good news.
Lots of great insight in there. This is the conversation I was hoping to have, just to get a better understanding of the larger picture of what else was won in the Kennedy decision. Thank you, Kelly. Thank you, Jeff. I so appreciate the work that you do. You guys are the best there is, and I'm grateful that you're applying your skill and your talent to this particular fight.
Thank you.
Thanks.
If you value analysis like this, I just want to invite you. You really should subscribe to our First Liberty Insider. It comes out every Friday. If you go to firstliberty.org, scroll down the page a bit, and there's a button there that says Become an Insider. It'll give you a deeper look each week at the issues surrounding religious liberty. We will see you next week. First Liberty, of course, is the last line of defense and the greatest hope for victory.